Now I am going to dictate a legal passage based on Kolkata High Court judgments on criminal matters at the rate of 120 words per minute. Let's start. A court of sessions under section 9 of the code comprises of a principal judge, namely, the sessions judge, as well as such a number of additional sessions judges and assistant sessions judges as may be appointed by the High Court. Therefore, an appeal against an order of conviction and sentence under subsection 3 of section 374 CRPC filed before an additional sessions judge who is a constituent of the Court of Sessions in terms of the impugned notification cannot be said to be contrary to the provisions of the Code of Criminal Procedure, particularly section 374 within bracket 3 thereof. Bail once granted can be cancelled if and when it is found that the accused after being released on bail abuses the liberties given to him. In other words, the conduct of the accused subsequent to the granting of bail is an important factor while considering any application for cancellation of bail. The remand order passed by the jurisdiction magistrate alone has to be legally considered as first remand for all the practical purposes. In the case of CBI versus Anupam J. Kulkarni within bracket Supra, the Honorable Supreme Court has clearly laid down that the period of 90 days or 60 days has to be computed from the date of detention as per the orders of the magistrate and not from the date of arrest by the police staff. Consequently, the first period of 15 days mentioned in section 167 within bracket 2 has to be computed from the date of such detention, and after the expiry of the period of first 15 days it should be only judicial custody. Apart from balancing aggravating circumstances and mitigating circumstances for arriving at the conclusion whether the case falls within the category of rearrest of the rear warranting death penalty, the Supreme Court has formulated crime test, criminal test and RR test for awarding death sentence in Shankar Kishan Rao Khade versus State of Maharashtra reported in within bracket 2013 5 SCC 546. It is not necessary that the inquest report must record the name of the assailant. The inquest report is mainly about the matter in which the body of the victim was found, which assists in the investigation of the crime. A sentence of imprisonment relates to person's right to personal liberty, which is one of the most important rights available to an individual, and therefore the court should be very reluctant to shut out a consideration of the case on merits, on grounds of limitation or any other similar technicalities. Defects in investigation cannot be a ground for acquittal of the accused. So, failure to send the seized weapon of offense to forensic science laboratory in the circumstances of the case is no more than a deficiency in the investigation, and such a deficiency does not lead to the conclusion that the prosecution case is unworthy of credence. Once the prosecution is able to prove that the victim was last seen alive together with the accused and the time gap is too short, between the time, found alive and dead, the provisions of section 106 of the Evidence Act at once attracted at the on us automatically shifts on the accused to explain as to how and under what circumstances the victim suffered a homicidal death and to prove their innocence, since such a fact is especially within their knowledge. In absence thereof, it is the accused who should own the liability of murder. The Supreme Court has held in Hassan Bhai Bhali Bhai Qureshi versus State of Gujarat reported in 2004 C CRLR within bracket SC 865 that the police can carry out further investigation without seeking any permission from the court even when the court has taken cognizance of the offence on the basis of the police report submitted earlier on completion of investigation. Stop. Thank you.